Good morning. May it please the Court? My name is James McNally. I'm appearing on behalf of the appellant, who is also the plaintiff, Earl Allard. This, of course, is a divorce case, and one of the main issues is when you have an antenuptial agreement. Incidentally, I'd like to reserve 7 minutes for rebuttal.
You have to manage your own time.
When you have a valid and enforceable antenuptial agreement, what does that mean? Does it mean it's valid? Does it mean it's enforceable? Or is it kind of like the pirate code in Pirates of the Caribbean, not so much a rule as a guideline? The Court of Appeals properly ruled, as did the court below, that a valid and enforceable antenuptial agreement is valid and enforceable, and that it does guide the entire course of the litigation. Now, obviously, one of the issues that arose, and is an issue that we're going to, that was included in this court's leave order, was whether two statutes apply to trump that principle of the contract. And I'll get to that second. I do want to point out that there was no cross appeal, so the appellee should not be able to improve her position here in this court. So even if you determine that the statute should be applied, no remand order should be put into effect. It will apply to future cases, but not to this case. And I'll comment on that a little bit more when I reach the statute issue. The other issue that was ordered by the court and briefed by the parties is whether real estate held by limited liability corporations can be attached by the divorce court brought into the marital estate. We take the position, and we're in agreement with the amicus brief from the business law section, that those assets are insulated from attack by or invasion by the trial court. Part of the fallacy, I think, and it's shown a little bit in the Court of Appeals opinion, is first the assumption that Mr. Allard acquired a lot of property and put it into LLCs. Now, there were a couple properties that he purchased in his own name, which should fall within the antenuptial agreement because they were titled in his name, and he transferred those into LLCs. But the remainder of the property, the vast majority of the property, was purchased by the LLCs, and it was used for LLC business. Mr. Allard runs several businesses, and these are legitimate businesses. He runs a type of rehabilitation facility for injury patients. He runs a transportation company that makes sure that they're able to go back and forth to the various healthcare providers. And he runs some rental properties between apartments and rental houses on Detroit's east side suburbs. These are legitimate companies, and they made legitimate business purchases as part of their legitimate business. It wasn't Mr. Allard buying all kinds of property and then hiding it in an LLC. The other confusion, I think, that comes out of the Court of Appeals decision, and this was something, again, that the court ordered that we brief, is how the LLC issue affects the marital home and income from the LLCs. Let me start with the marital home. That was a pre-marriage property, and it was disclosed in the antenuptial agreement's schedule of assets. That should be outside the consideration. I think that'll take care of that. Income from the LLCs is another issue because we get into the question of what is income. The Court of Appeals felt that income and property were two different things. And I think that's a confusing point of view for them to take, because income is a ledger entry. Even if it's reflected on Mr. Allard's tax returns under Schedule C, as it was, it's not money in his pocket, it's money in the corporation that, through the pass-through of the tax code, ended up on his tax return. So what is income? Well, income, if you consult the legal dictionaries, is money that you earn from a business or from wages or whatever. And
Can I direct you to
absolutely.
Section 5 of the agreement?
Yes.
This is where the prenup attempts to lay out what is excluded from marital property. And generally, the lead-in says, look, all the statutory rights you might have, you're waiving.
Yes.
They're released. And then it says, however, notwithstanding the above, the following property acquired after marriage will remain in the sole separate property of the party acquiring the property and or named on the property. A, as provided in paragraphs 2 and 3, any increase in the value of any property, rents, and interestingly, profits or dividends arising from the property previously owned by either party shall remain in the sole and separate property of that party. I find it interesting that in Section B, that concerns the property acquired after the marriage, that there is no reference to dividends and income.
That's correct.
Now, isn't that a significant textual clue that your client did not intend to exclude from marital property income thrown off by the property?
No, and the reason is that 5B primarily addresses the titling of assets. And like I said, income is a ledger entry until it ends up in his bank account or in his pocket. And at that point, it's titled in his name.
I guess I could argue that from these being separate legal entities, as soon as they declare a dividend, that ceases to be the property of the corporation and becomes income to him.
Yes. It's already income.
Well, but it becomes distinct from the property of the corporation when they declare a dividend to him.
It goes into his name. It's a distribution, whether it's a dividend, a wage, or whatever. Now it's in his name, and it falls under 5B because it's property titled in his name. Just as if he
well,
would...
they use property. Property is used in both, but in the A, it goes on to distinguish between what looks like perhaps real property or anything, I guess personal property, but then it talks about rents and profits and dividends. And those are missing in the provision that has to do with the... I'm having difficulty understanding your argument as to why when there's a specific recognition that income thrown off by the property acquired before the marriage is recognized, but after the marriage there's no such recognition.
The reason that that's in there, from what I understand, and I grant you that they do not have a parallel structure before marriage, after marriage, but that 5A was intended to cover the fact that there are court cases out there that say if you have a premarital asset, the appreciation in value of that asset may become a piece of marital property.
Gotcha. Understood that.
That's the distinction.
That's covered. They figured out increase in the value of the property before marriage, property acquired before marriage, is not in the marital estate.
Right.
Covered that. What they didn't seem to cover in B is the appreciation of assets acquired after marriage.
I realize that, and I think it's because it all fell within that umbrella of being titled in sole name that they felt that there was not that necessity. The next one we write might look different.
I bet.
But at this point, our focus being on B, I recognize there's not a parallel structure.
Isn't that a for a court that pays attention to the words the parties use, isn't that a pretty significant omission?
I don't think so. And the reason is, I think that the property here fell into one of two categories. It was either LLC property, which is protected by the LLC laws, or it was individual property, which is protected by 5B by being titled in his name.
Okay.
So I think that either way, these particular assets, the LLC property, is going to be protected one way or the other. And of course, this is where we piggyback substantially on what the business law section put in their amicus brief about how you can't bring in LLC assets as part of the marital estate. You can't force
Until
LLC.
they're distributed.
Sorry?
Until they're distributed.
Until they're distributed, yes. But then they fall under 5B. That's our position on that. Now, I'm glad that you've recognized the distinction between income and the distribution, because that's important as well. The fact that a company made income and that it was reflected on Schedule C of Form 1040 doesn't mean that that actually ended up in the taxpayer's pocket. It is a pass-through. So it's not as easy as saying that the company made $200,000, therefore you have $200,000 of assets to be distributed through the marital estate. It obviously takes a more precise approach to all that.
Can I ask you a question
Yes.
about the same language that the Chief Justice has just focused on? And I fully agree with him that a court would look at this language and try to give it a close and disciplined interpretation, and I guess I'm trying to do that too. I would look at the very same language the Chief Justice has cited, but I have a slightly different question. It says, it refers to property acquired after the marriage will remain the sole and separate property of the party acquiring the property and or named on the property. You assume that this language establishes a rule or governs the final division of the property in the trial court's judgment of divorce. However, it seems to me there's some ambiguity here. An alternative reading of this language is that it simply defines which property is separate and which property is marital, which would then still allow the trial court to invade either one of the parties' separate estates pursuant to 552.23 and 552.401 in order to effect an equitable judgment of divorce. Now, perhaps this is a subject that would have been better for the cross appeal, but nonetheless, is it susceptible to that ambiguity?
No, and I think the Court of Appeals didn't find that it was ambiguous. I think that they felt that it was unambiguous that this property, the LLC property, should be considered by the trial court because it was not titled in Mr. Allard's name. Of course, a lot of things aren't titled in his name. His brother's house isn't. So that doesn't bring it outside the prenup and into the marital estate. We still have to look at what this agreement defines. And this agreement, laying aside the effect of the statutes, this agreement says that whatever property ends up in Mr. Allard's name is going to be his at the conclusion of the divorce. Now, you do have the invasion statutes, and that is, I believe, a better subject for a cross appeal. However, those statutes are not mandatory. They use the word may. We know that statutes and even constitutional provisions could be waived by the parties. There's nothing in the statute that would imply otherwise, and all the cases that get cited allow it. The only case that was against that would be Reed, but that was dicta. The other
Pretty
thing,
explicit waiver and release in the prenup, right?
yes, and when the family law section in their amicus brief said that there should be an explicit waiver of these types of rights, other than citing statutes, which might not be appropriate if these people move to Ohio, it did say that we waive all the statutes, now, current, future, in this state or other jurisdictions. It was a pretty broad and clear waiver of rights. So now we have to confront the issue of whether those statutes are their last possible defense. Whatever you rule for the future, In this case, the court did not limit evidence. There were multiple times when the issue arose during the trial. Before the trial, during the trial, there was a motion in limine midway through the trial. How far does our evidence go? And while the court expressed its belief in the prenup, it still said you can bring that evidence in. I'll listen to it. They were not restricted in the evidence that they were allowed to bring, but when they were asked, what kind of evidence do you have, they had to say, we really don't have much. Because their principal attack was not that LLC property is titled in the LLC and therefore not titled in Mr. Allard's name and outside the scope of 5B. Their argument was the wife contributed to the marriage under Hanaway, and therefore you have a marriage partnership where property can come in. And the other one was that marital assets were used to purchase these assets.
Well, on that point, that latter point, if the court were to disagree with you that the prenup encompasses income distributions from the LLCs to Mr. Allard, and therefore become income to him, and doesn't that mean that that money is subject to the marital estate?
If you disagree with our position, yes, that brings it in.
What happens, what should we do if that's our conclusion? I'm not saying it is, but if we conclude that the prenup does not exclude or does not keep within his estate the income distributions from the LLCs, what should we do?
This is a difficult question because I know that the court is very conscientious when it writes remand orders. The proofs in this trial don't lead you to a particular remand order. It doesn't say, you couldn't say just rely on.
If this court reaches the conclusion that there was income,
right,
neither the trial court nor the Court of Appeals assess that.
Right. And I'm suggesting that you have to kind of keep it open-ended because that's when we start to bring in the accountants that say that the fact that it's declared as income doesn't make it income to Mr. Allard. So the Court of Appeals kind of was a little too precise by misinterpreting what income is. For example, they relied on the business income statute, which parallels the Internal Revenue Code, but it says business income is income earned in a business. It doesn't.
Well, they made all the assets essentially of the LLC as part of the
Yes, they did.
estate.
Yes, they did, which is why we're here. So I'm suggesting that if you disagree with me, we need to keep it open-ended enough that there can be the proper proofs.
What does the remand order then say? You're saying just because it's a distribution doesn't make it income. Is that what you're saying?
No, what I'm saying is just because it's income doesn't make it a distribution. And I'm saying
No. I think I'm being fairly, I'm trying to be precise. The assets within the corporations are the assets of the corporations.
Yes.
Until such time as they issue a distribution of those assets to the owner.
Right.
It's that point at which arguably that income, the distribution, let's use that.
Yeah,
The
thank you.
distribution becomes a marital asset that neither the trial court nor the Court of Appeals assessed as to its appropriate treatment.
Right. But I'm going to disagree with the word marital asset. Let's just say that when it's distributed, it becomes an asset in an individual name, because the distribution would be made to Mr. Allard, and it would be reflected on his tax return, whether he's filing jointly or separately.
But whether it's in his name or not, isn't it a marital asset at that point? Isn't the distribution a marital asset?
In a case without a prenup, yes.
Well, or in a case with this specific prenup.
Then it's not, because 5B says that that is property titled in his name. Money is property. Income, when it goes into your bank account, becomes an asset. It becomes property.
Except if we're trying to understand the relationship between how A is worded and B is worded. It suggests that property has a different meaning than rent, profit, or dividends. It doesn't say any property including, so that we understand that we're not limiting property. When you put a comma after property and then add rents, profits, or dividends, it suggests that they're different from property. Does it not?
In some ways of interpreting contracts and statutes, it could. The way that I'm suggesting is A was there for a specific purpose, and that was to protect the appreciation of value. And
Understood.
B is separate.
That's already dealt with. Any increase in the value of property, if it stopped there, that would cover what you're saying.
Well, it would cover appreciation. It wouldn't cover rents, for example.
Correct.
Yeah. And what I'm suggesting is that A in this analysis is a red herring when we're discussing the issue of how assets are titled. And this goes back to the Reed case. Greg Reed put everything in his name, and he had LLCs and all that too. So I think our disagreement here is
I'm just trying to understand.
A affects
I may not. I'm just trying to understand
all right.
how to parse the language.
Okay. All right. I wanted to highlight that I think I've made the issues clear.
And you don't have to talk anymore.
That's what I'm hoping for.
All right. You can sit. I hear no questions for the moment.
Thank you.
Good morning. May it please the court. Kevin Gentry on behalf of the appellee, Christine Allard. There's two issues that we are here today on, and one of which was not discussed very much, but I think the statutory interpretation issue does obviously have the attention of the court, and that I did want to touch on a little bit. There's three statutes at least that have to be discussed. 55728, which affects antenuptial agreements as to property, not as to support or attorney's fees. That's an interesting thought. Additionally, we have 401 and 23, which both address invasion of separate property. The way to construe a prenup agreement in this case, and really in any case, if we're going to give effect to all of the statutes rather than just what the Court of Appeals did, which said 55728, which doesn't even talk about divorce, somehow trumps two statutes that do specifically talk about divorce. But the way to give effect to all of them, a prenuptial agreement sets out what is separate property. Contrary to Byington, contrary to Cunningham, that parties can do whatever they want and decide what is separate property. Then, once that's done, it goes before the court, and the statutes still apply unless they are very specifically waived. And there's a waiver here as far as any statutes, but they're not waiving any statutes. They still want a divorce. They still want 552.12. They still want 552.19. So that is not the specificity level that we need to see in a waiver, analogizing the staple, which I think was fairly well thought of on that point. I'm not positive that a waiver is even possible here, though, because we have statutory mandates, not statutory rights. Let's compare this to staple for a minute. 552.28, upon petition of either party, it's a right of the parties. Section 401 and Section 23, those are duties of the court. Those are mandates. I think they're different. And turning a bit to the issue of the separate properties, well beyond this case, consider for a moment if entirely property in an LLC is not marital property anymore. Even the least sophisticated party could remove from Michigan divorce court jurisdiction any particular real estate holdings or whatever else they might have by placing it in an LLC. The statute dealing with LLCs, Section 506, treats single-member LLCs differently than it treats multi-member LLCs. And there's a reason for that. And that is single members have control, dominion and control over an LLC far different than multi-member LLCs do. The statute permits that by agreement of the single member and the other party, the interest can actually be transferred. And just as with the court ordering a title to be transferred from one to another, that can be accomplished by way of the court order. Finally, the family law section's point about a revocable trust being another good example of a vehicle. It is a separate legal entity, but it's still a vehicle to possess marital property. And that's really what we're talking about here is can the courts actually effect their duty, 552.12, of doing equity in looking at the whole marital estate, or are anyone with even a very small amount of sophistication able to move whatever assets of the marriage they wish out of the area? And with that, I'll be happy to entertain questions.
Good. Here's my concern. I thought the Court of Appeals consideration of these LLCs and their property was incoherent, at least in terms of how we normally understand corporate entities and their assets. They are separate from their owners, correct?
Correct.
The Court of Appeals didn't seem to recognize that.
It was a very, even as the appellee, I'll admit, it was a very difficult to follow opinion.
All right. So let's sort of start there. I thought the thesis of your opening remarks was, hey, you can't disregard these assets in the LLC. The court has to be able to consider those to do equity. Is that a fair?
That's a fair assessment of my initial position. I've got some alternatives, but
Okay.
that's my starting
here,
point.
I'm just trying to figure out how this universe works. You believe, do you not, that it is lawful for a party to waive rights under the various statutes that form the divorce?
Correct. If it's a party's rights, I believe they can be waived. I'm not so sure that a mandate to a court can be.
All right. Well, but it does affect, if the parties can allocate by an agreement, a prenup, what's an asset in the marital estate and otherwise, that's at least a starting point. But let me ask you to look at paragraph 5 of this prenup agreement. This is designed, it seems, in anticipation of a divorce. It's looking forward then to a bad result of this marriage. And it says, if that happens, in full satisfaction, settlement, and discharge of any and all rights and claims of alimony, support, and importantly, property division or other rights of any kind or description under the present or future statutes and law of common law of the state of Michigan or any other jurisdiction, all of which are hereby waived and released. I'm trying to figure out how you could have a more comprehensive release and waiver of these statutory rights.
I think the exact synonym to this release is Michigan law doesn't apply.
I'm sorry?
I think the synonym to this release is Michigan law doesn't apply. I mean, that's really what it's saying. And I think that's a bridge too far.
As to property, in the event of a divorce.
Property, alimony, property. I mean, the claims of, these are within the province of the parties to allocate the resources. What you're saying is they can't affect the jurisdiction of the court, right?
I'm saying they can't affect not only the jurisdiction of the court, but the duty of the court to do equity. I'm saying that the...
Well, let's just start with the allocation.
Okay.
They can certainly waive how they allocate their property as between individual estates and marital estates.
Between separate and marital property?
Right.
Yes, they can.
Okay. Now, when they have done so, why does the court then get to invade them, especially when there seems to be a pretty explicit premarital waiver of that?
Because the legislature has determined that that's an appropriate policy.
Okay. I think I understand your position.
And where?
In 552, 401, and 23, in both cases, the legislature is pointing to a specific time in which a court may, to do its duty of equity under Section 12, invade separate property to either address the equitable consideration of contribution, accumulation, helping build, or to address the equitable consideration of not impoverishing the party.
The court didn't, though.
Here the court thought it was unable to. It was unable to consider either of those.
Okay.
Is it prenuptial advisory?
I think, Justice Bernstein, if I understand your question, is the prenuptial advisory to the circuit court?
Yeah, I guess basically on Brother Counsel, he was saying that's the core issue of this. Are prenuptial agreements advisory, or are they fully enforceable? So
No.
would it be your contention that they're advisory, or are they fully enforceable?
I think they're fully enforceable to the extent they're legally allowed, and I think that a prenuptial agreement can define separate and marital property, and I think this one probably does. The question then becomes, okay, it's become separate and marital property. Now, two issues there. One is, does income or dividends included, which it doesn't appear to be under the language of this prenup. And two, if it is separate property, may the court then invade it for contribution or need?
So how could this have been written differently as to avoid this entire discussion?
If, and
I
this
think
is
your
an
position
if.
is it can't.
I'm sorry? My initial position is it can't. An alternative, if it is, I think it's got to say that specifically. It's got to say specifically what it's doing. If you waive, for example, the right to a preliminary examination, that's entirely statutory. The legislature just decided we should have one. And you waive that. You have to say what it is you're waiving. If you waive just the fact that you're going to not have it within 14 days, you have to say what it is you're waiving. And that is what is absent here, is by saying everything, no, not everything, because you still want a Michigan divorce, you still want FENS in Michigan statutes. So tell us specifically what it is you're waiving.
Division of property.
All rights and claims of alimony support property division.
That's what the subject is.
That's
That's
what
pretty
the-
specific, right?
That's what the subject is, and I'm suggesting that,
The waiver as to those issues, claims arising under alimony, etc.
and I'm suggesting the legislature's mandates cannot be waived because the mandates point to the trial court. That's very different than 552.28, where it's a right of the parties.
Okay.
There's nothing further. Thank you, Honors, for your time.
Thank you. Anything further?
Just
Why
brief.
isn't he right?
I'm sorry?
Why isn't he right as to section 55, 520, I'm sorry, 553.23? That is a mandate to the circuit court, not the parties.
We have to look at the wording of the statute. The statutes both say may. The
Okay.
legislature is not.
All right, so if that's the determinative issue, you're not saying the court can't, it just didn't in this particular incident.
Right.
It could have.
Oh, I believe so, and I believe the court actually did, because the court took in that evidence.
Well, I make sure I understand your point. So the release language we've been talking about here does not waive or release the trial court's statutory authority to invade property that is made clear under the prenup is not marital property.
I believe that the parties can waive it entirely.
Well, tell me that. Well, that's different than saying the court didn't exercise that authority. How is it that the parties by agreement can waive a right or an authority that goes to the circuit court, not to their particular rights under the statute?
It's not a right that goes to the circuit court. It's a power that goes to the circuit court.
All right, I'll take that friendly amendment. How can they waive an authority granted to the circuit court?
Power.
Power. Sorry, thank you.
Power and authority and jurisdiction will put all together. The reason they can do that is because they have free will. We're going back to the whole contract
They have the right to
principle.
write the contract. The question is, can the contract, through their joint free will, contradict the legislative authority or power given to the circuit court?
The answer is yes, just as parties can create their own limitations periods for bringing claims, although the legislature has its own statutes of limitations and no provision that says the parties can waive these or shorten them.
Well, an agreement will stop a party from acting inconsistent with the agreement, but I don't understand how that operates as an estoppel against the authority or power of the circuit court.
It limits the court's power because the contract is valid and enforceable. And as a result, even in ordinary contract cases, parties are precluded from bringing evidence about how that contract is
But
unfair.
a prosecutor and a defense attorney can make an agreement
Yes.
to a particular sentence, but the court doesn't have to accept that.
Correct.
So why isn't that just like this? So it's an agreement that's sort of presumptively enforceable as between those two parties, but the court nonetheless doesn't have to accept that.
Using contract principles is the reason. And in a criminal case, I hate to bring criminal cases into this because the court has a higher responsibility to the Constitution and to the public.
Well,
It's
Then
a
to enforce the
gatekeeper.
law?
What's that?
Then to enforce the law uniformly across the board?
That is part of the Constitution. Of course, the court has the responsibility to uniformly apply the law. In a prenup case, you apply the law of contracts, supplemented to some degree by equitable principles and filling in blanks.
But that's exactly what 552.23 says. The parties, whether they've done it by agreement or by practice, they've got an array of assets which the court, in its equitable jurisdiction, may invade to make things right.
Yes.
I'm still struggling with how it is a contract varies the authority or power of the circuit court.
The same way it does in these other contract cases.
But they don't, typically you can by contract waive a right that a statute gives you. The statute just involved here at 552.23 is not a right that is given to the parties, it is a power given to the court.
They're just flip sides of the same coin, though.
Not quite. The authority, I don't think you can contract away my authority as a justice. I'm having trouble.
I think you can, actually, his. I think you can.
They can, but you can't.
Some of us have been working on it behind the scenes. Sorry,
I'm sorry. That's where I'm floundering. I can't quite understand. I can understand every time the legislature says a party has a right to this, a dower or alimony, that I can waive. When the legislature says the court shall have the authority to do equity, I'm having trouble understanding how I can contract away the trial court's power.
and I submit that it's the same way in these other contract cases, that a court takes the cases that are given to it.
Yeah.
Now, what you've touched on goes into the Omni financial issue, but that was an entirely different issue. That was the case where the court said you can't contractually agree to venue in a particular court. And I remember when that case came out, it was 1999, and it kind of sent a shockwave about what can parties do to limit what a court can do. Can they submit a contract that gives jurisdiction beyond the jurisdictional amount to a particular court? Can they give a municipal court full equity powers under a contract? And there, the court was defending its ability, both under the legislation and the court rules, to determine venue. And what you're suggesting probably touches onto that. The question of how far can courts go to protect their bailiwick, their power, their jurisdiction, their authority. And what we've seen in these prenup cases was there was originally a jealous protection of the court's power. And we've seen that erode over time and giving way to the idea that contracts can enter into this. We saw the same thing with arbitration.
Yeah, but
now
where
we
does
have
that
marital
come from in
arbitration.
law? I mean, you're telling me this is what has kind of happened, but what's the authority for that proposition? Where do I look to say, oh, I see, that's the rule?
It's an evolution, but the rules are found in these other cases that eventually accepted arbitration, eventually accepted prenups, and other
Well,
contracts.
there's an explicit statute now that says they're enforceable.
Yes, Yes, and
But
that
that-
statute's been around for a while, too.
But all that statute says is a contract relating to property made between persons in contemplation of marriage shall remain in full force after the marriage takes place, which suggests that it's trying to overcome some common law notion that husbands and wives can't contract with each other because once they become married, they're the same legal person.
And there was also the
So,
concern,
great.
when prenups started emerging, whether wives could make decisions about their own property.
So great, but that still doesn't tell me whether or not these invasion statutes trump the contract. I'm just left with the impression that 557.28 doesn't do much.
Other than the word full effect.
Sure, it remains in full force after the marriage takes place, but that doesn't answer the question whether it's still subject to the invasion statute.
I wish I could give you more direction on that. I just think that it's found in those prior decisions that start to surrender some of that jurisdiction that the courts protected. And I just wanted to make one quick comment. The reason that the LLC discussion in the Court of Appeals opinion is so disjointed or incoherent is because they had no guidance. This was not an issue that was developed at trial, and it was not an issue that was briefed by any of the parties, so they didn't have that roadmap that we may have provided.
They didn't have law.
I believe they had equity in their mind.
Okay. Thank you very much.
Thank you.
Case is submitted.